Hello dear students, I, Dr. Anuradha Goswami, Associate Professor from the Department of Commerce, Bhopal School of Social Sciences, welcome you all for this video presentation entitled The Indian Contract Act 1872. In this video presentation, I will briefly discuss the introductory part of the Indian Contract Act 1872, and our focal area of discussion would be the essentials of a valid contract. The Indian Contract Act is the most important constituent of Indian mercantile law. The Indian Contract Act 1872 governs the law concerning contracts in India. This law regulates the conditions in which commitments made by parties to a contract shall be legally binding and the enforcement of their rights and duties. The Indian Contract Act came into effect on the 1st of September 1872 and it is applicable to the whole of India. The Indian Contract Act is divided into two parts. The first part is from section 1 to section 75, which deals with the general principles and it applies to all the contracts irrespective of their nature. The second part, comprising from section 124 to section 238, deals with certain special kind of contract like indemnity, guarantee, bailment, pledge and agency. The main objective of this act is to ensure that both the parties under contract must fulfill their obligations towards each other as per the terms and conditions of the agreement. In case any party become the defaulter, then the aggrieved party has a right to seek the legal remedy. The word contract has been derived from the Latin word contractum, which means to bring together. Contract is a legal term which means an agreement between two parties that create mutual legal obligation. A contract can be either oral or written. However, oral contracts are more challenging to enforce, hence they should be avoided if possible. Now take a look at the various definitions that you can see on the slide in front of you. These are the three definitions given by Pollock, Halsbury and Selmond. But based on the analysis of all these three definitions, we can conclude that the contract consists of two essential elements. The first element is agreement and the second element is enforceability by law. In simple words, an agreement means a promise. It is created when a person makes an offer to another person and that other person accepts it. Thus, agreement equals to offer plus acceptance. Legal enforceability means creating a legally binding obligation between two parties. If any one party fails to fulfill his obligation, the other party can take the help of a law to enforce it. Thus, from the above definition, we can easily conclude that contract equals to accepted proposal plus enforceable by law. I'll take an example for easy understanding of these elements. Suppose Divyata asked Alisha, will you purchase my Alto red color car 2015 model at the cost of Rs 65,000. This question asked by Divyata is an offer. Alisha said yes to Divyata's offer. Here, Alisha's yes is treated as an acceptance. The mutual understanding between Divyata and Alisha about their reciprocal rights and duties is termed as an agreement. If after having an agreement, either Divyata or Alisha does not fulfill their promise, the suffering party has a right to file a case against the defaulter. Since sale and purchase of a second-hand car is an absolute permissible legal transaction in India, it means this agreement is enforceable by law. Hence, they both are under a valid contract due to the presence of following required elements, that is offer, acceptance, agreement and enforceability by law. Here we have to keep 2 points in mind. The law of contract is concerned only with those obligations which arise out of agreement and it deals only with those agreements which create legal duties or relation. Now dear students, I am going to discuss all the essential elements of a valid contract. According to section 10 of the Indian Contract Act 1872, all agreements are contract if they are made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object and are not expressly declared void. Other than these, there are some other essentials which we can interpret from the context of the contract or through interpretation of the various judgments of the Indian judiciary. Now, let us see these points one by one. The first essential point of a valid contract is plurality of parties. It simply means for every valid contract, there should be minimum of 2 people. One person is required to give an offer, another one is required to accept an offer. Person in this context could be a natural person, that is an individual like Divita and Alicia, or it could be an artificial legal person like company, school, etc. The point to be kept in mind is that there could be more than 2 persons under a contract but not less than 2. The second essential ingredient of a valid contract is an agreement. According to section 2 subsection E, every promise or set of promise forming consideration for each other is agreement. An agreement occurs when 2 minds meet upon a common purpose. They mean the same thing in the same sense at the same time. Hence, in order to create a valid contract, there must be an agreement between 2 parties, that is, lawful offer of one party followed by unlawful acceptance of that offer by another party. Thus, only proposal or acceptance without a proposal cannot constitute an agreement. In our example, when Divita proposes to sell her car at Rs 65,000 and Alicia accepts this proposal, it is a valid agreement between them because, as we already know, offer plus acceptance is equals to agreement. The third essential element of a valid contract is that there must be an intention among the parties that the agreement should be attached by legal consequences and legal obligations. Hence, both offer and acceptance must be made with the intention of creating legal relation between the parties. If there is no such intention on the part of the parties, there is no contract between them. They should have an intention to impose duty on the promiser to fulfill their promise and bestow a right on the promisee to claim its fulfillment. Here, the point to be kept in mind is that social or domestic agreement between relatives or neighbors are not enforceable in a court of law as they do not contemplate legal relationship, and thus any such agreement cannot become a valid contract. For instance, if a father fails to give his daughter the promised pocket money, the daughter cannot sue the father because it was purely a domestic arrangement. Thus, it is clear that all agreements which do not result in a legal relations are not contracts. The fourth essential element of a valid contract is contractual capacity. According to section 11 of the Indian Contract Act 1872, a person competent enough to contract are: number 1, a person who is of the age of majority according to the law to which he is subject. It means the person must be at least 18 years old or above. The second condition is the person should be of sound mind. It means the person should be able to fully understand the terms or promises of the contract at the time of the formulation of the contract. The third condition is person should not be disqualified by any another law prevailing in India. It means the party should not be disqualified by any other legal ramification. For example, if a person is a convict, a foreign sovereign or alien enemy, they may not enter into a contract. The fifth element of valid contract is consent or consensus ad idem. The term consensus ad idem has been defined under section 13 of the Indian Contract Act as meeting of mind or identity of mind or receiving the same thing in the same sense at the same time. Consent simply means that the offerer and the acceptor of the contract must have agreed upon the subject matter of the agreement in the same sense and at the same time, because an agreement without consent is not legally binding and there can be no contract. In our example, Divita and Alicia do understand completely that they are agreeing for a sale of an Alto red color 1995 model car for Rs 65,000. Hence, they have a consent or consensus ad idem among them. The sixth and very important element of a valid contract is free consent. It is essential that there must be free and genuine consent of the parties so as to create a valid contract. If the consent of either of the party is taken by coercion, undue influence, fraud, misrepresentation or mistake, then it is not treated as a free consent. In such cases, the contract becomes voidable at the option of the party who does not give his or her consent freely. Hence, both the parties should agree to the terms and conditions of the contract as per their own sweet will and without forcing each other in any manner. The seventh essential of a valid contract is consideration. Consideration basically means a reasonable, equivalent or corresponding benefit being passed on by the promisor to the promisee. It is something which is of some value in the eye of law. To make an agreement as valid contract, it must be supported by consideration. Gracious promises are not enforceable at law as no cause of action arise out of bare promise. In our example, Alisha promised to pay rupees 65,000 is the consideration for Divita, and Divita's promise to sell the car is the consideration for Alisha. Hence, it is clear that consideration means something in return. Now, our eighth essential for valid contract is lawful object and lawful consideration. The consideration or object of an agreement is lawful unless it is forbidden by law or is of such a nature that if permitted, it would defeat the provisions of any law, or is fraudulent in any nature, or involves or implies injury to the person or property of another, or the court regard it as immoral or opposed to public policy. In each of these cases, the consideration or object of an agreement is said to be unlawful. The ninth essential of a valid contract is certainty of meaning. According to section 29 of the Indian Contract Act 1872, agreement the meaning of which is not certain or capable of being made certain are void. Therefore, to form a valid contract, it is absolutely essential that the terms and conditions of agreement must be clear instead of being vague or indefinite. In our example, if Divyata would have simply said that she wants to sell her vehicle, as there is nothing to show what type of vehicle she intends to sell, hence the agreement would have been void due to the absence of certainty. Since Divyata has provided all specification including type, color and year of manufacturing of the car which she intends to sell, hence there would be a valid contract between Divyata and Alisha. The 10th essential of a valid contract is possibility of performance. It means the term of the agreement must be capable of being performed by a human being and should not enforce impossible acts. If the act is impossible in itself, physically or legally, it cannot be enforced at law because as per section 56 of the Indian Contract Act, an agreement to do an impossible act is void ab initio. In order to clarify this point, I would like to take help of the following example. Suppose two people decide to get into an agreement where a person agrees to bring another person back to the life. Even when all the parties agree and all other conditions of a contract are satisfied, this is not a valid contract because bringing someone back from the dead is an impossible task. Thus, the agreement is not possible to be enforced and the contract is not valid. The 11th essential of a valid contract is that it should not be based on agreements declared void by any law in force in the country. A void agreement is one which is without any legal effects. Illegal agreement is an agreement expressly or impliedly prohibited by law, hence punishable in nature. In the Indian Contract Act, agreement mentioned in section 24 to section 30 have been expressly declared to be void. For example, agreement and restraint of trade, marriage or of legal proceeding, wagering agreements, agreement without consideration, agreement with unlawful consideration, agreement made by incompetent parties fall under this category. The 12th essential of a valid contract, especially in case of written contract, is compliance of legal formalities. Although Indian Contract Act does not provide any formality to enter into a contract, therefore, a contract may be oral or written or even implied. An oral contract is a perfect valid contract except in those cases where writing or registration is required by some statute. In India, writing is required in case of sale, mortgage, lease and gift of immovable property, negotiable instrument, etc. Registration is required in case of documents coming within the scope of section 17 of the Registration Act. In the absence of required legal formalities, the contract loses its enforceability. Now, dear students, I would like to conclude this presentation by reconfirming the fact that if the parties to an agreement want to make legally enforceable contract, then the contract should satisfy all the conditions stated in Section 10 of the Indian Contract Act. If any of these conditions is not satisfied, a contract will not be enforceable at law. Dear students, the following essentials of a valid contract, namely offer, acceptance, capacity of a party to contract, free consent, consideration, expressly declared void agreement, would be taught to you in depth in our next video presentation. Thank you, dear students. I hope this video presentation will help you in understanding the introductory part of the Indian Contract Act 1872 and as well as the essentials of a valid contract.